If you have more than 15 employees as of June 18th, 2024, you are now subject to the Pregnant Workers Fairness Act. In this video, I'm going to break down what is the Pregnant Workers Fairness Act, what you need to do to be compliant, and more about who is subject to this latest piece of legislation. HR has been called death by a thousand cuts. And this, while a great law and regulation, is just another example of the constant things we've got to keep up with as business owners and HR professionals to keep our organizations compliant. So what is the Pregnant Workers Fairness Act? Well, effective June 18th, 2024, this law went into place to mandate that employers with more than 15 employees provide reasonable accommodations for workers affected by pregnancy, childbirth, or related medical conditions. So what does this mean for you as an employer? How does it differ from existing laws like the ADA, Americans with Disabilities Act? Well, I'm going to break that down in this video and provide a comprehensive overview of what you need to know to remain compliant and supportive of your team. So what is the PWFA? Well, the PWFA is a significant step forward in protecting the rights of pregnant workers in the U.S. So while the ADA has long provided protections for pregnant workers or with disabilities, the PWFA specifically addresses the needs of pregnant workers. So unlike the ADA, the PWFA does not require that a condition rise to the level of a disability for an employee to be eligible for accommodations. Instead, the law focuses on maintaining the health and ability of the individual to work during pregnancy and after childbirth. So the Pregnant Workers Fairness Act requires employers to provide reasonable accommodations to employees who are pregnant, have recently given birth, or are dealing with related medical conditions. These accommodations are intended to ensure that employees can continue to perform their duties safely and effectively. But most importantly, the law also modifies the documentation requirements, making it easier for the employee to request for accommodations. So the minimum documentation needed is enough to confirm the condition and describe the necessary adjustments at work due to the limitation. So who is covered under the PWFA? Well, PWFA applies to employers of 15 or more employees, as I mentioned, but one of the most notable aspects of the PWFA is its inclusion of abortion-related accommodations. So unlike some other laws that might tie such accommodations to insurance policies, the PWFA mandates that employers provide reasonable accommodations in these cases as well. So this is broad coverage. It reflects the law's intent to provide comprehensive protections for all aspects of pregnancy, childbirth, and related medical conditions, right? So that would fall into that related medical condition. So furthermore, the PWFA has a sweeping definition of what it means to be a qualified employee. So let's break that down. The law recognizes that there are essential job functions that an employee might temporarily be unable to perform due to pregnancy or related conditions. However, this temporary inability does not disqualify them from receiving accommodations under the PWFA. All right, so what are some of the key aspects of the PWFA? Well, first, it's that broad coverage like I spoke about. It's not only broad, but it's also covering abortion-related accommodations. The second is the qualification criteria for protection. So the law's definition of a qualified employee is intentionally very broad. This inclusivity means that many employees who might not have been considered eligible under protection under the ADA or other laws will now find themselves covered by the PWFA. For example, employees who temporarily cannot perform certain essential job functions due to pregnancy are still entitled to accommodations. The third big piece of this key aspect of the law is the understanding limitations under the PWFA. The term limitations within the context of the PWFA is also broadly defined. The law covers any known limitations related to pregnancy, childbirth, or related medical conditions. Importantly, these limitations do not need to be severe or disabling to qualify for accommodation. That's a really important thing to understand. The law is designed to protect even those with healthy and normal pregnancies, ensuring that they too can seek and receive reasonable accommodations as needed. The fourth key aspect of the law is the possible accommodations under the PWFA. So the PWFA includes a list of potential accommodations that employers might consider providing to pregnant workers. These accommodations are designed to help employees continue working safely and effectively during their pregnancy. Examples of reasonable accommodations under the PWFA might include more frequent breaks, modified work schedules, temporary reassignment to less strenuous or hazardous duties, or the provision of seating for jobs that typically require standing. The law encourages employers and employees to engage in an interactive process to determine the most appropriate accommodation for the employee's specific situation. The process is meant to be flexible, recognizing that every pregnancy is different and that the needs of each worker vary. Number 5, key aspect of the PWFA law is the documentation requirement. So one of the significant changes introduced by the PWFA is the modification of documentation requirements. Under the ADA, employers might require substantial medical documentation before granting accommodations. However, the PWFA reduces this burden, requiring only the minimum necessary documentation to confirm the condition and the need for accommodation. Employers can still request more documentation in certain cases, but the emphasis is on reducing unnecessary barriers for the worker or teammate to get the accommodations that they need. So number 6, key aspect of this law is denying accommodation requests. While the PWFA obligates employers to provide reasonable accommodations, there are circumstances where you can deny a request. The key term in this context is undue hardship. If providing a particular accommodation would cause significant difficulty or expense for the employer, they may be able to deny the request. However, the burden of proof, as always, falls squarely on the employer to demonstrate that the hardship is indeed undue. And the number 7 key aspect of this is its interaction with other laws. It's important to note that the PWFA does not replace other federal, state, or local laws that provide protections for workers affected by pregnancy, childbirth, or medical-related conditions. Instead, it's just adding another layer of protection, complementing the existing laws like the FMLA and the Pregnancy Discrimination Act. Employers need to know how all these laws come together. So how should you prepare as an organization for your PWFA compliance? Well, first and foremost, again, it took place on June 18th, 2024. So anytime you're watching this is after June 18th, because I'm filming it after June 18th. First and foremost, you need to review and update your policies. Make sure your handbook is up to date. Make sure that you've got current policies related to pregnancy, accommodations, and disabilities. Next, you need to train your HR and management team so that they understand the implications of this law and your requirements as an employer. Next up, you need to communicate with employees. Make sure that employees are aware of their rights under the PWFA. We need to provide information about how they can request accommodations and what documentation, if any, is needed. Step 4, engage in interactive processes. Like I mentioned earlier, when an employee requests an accommodation, engage in a collaborative process to determine the best solution. The process should be ongoing with adjustments made as necessary. And finally, seek legal or HR guidance as needed. If there are uncertainties about how to comply with the PWFA, reach out to an attorney, reach out to Guru, whoever you're most comfortable with. This can help ensure that your company is fully compliant with the law and that you are providing the necessary protections to your employees. So, final thoughts. If you need help with HR compliance related issues like this, please drop us a note, guhroo.co. The Pregnant Workers Fairness Act is a significant step forward in protecting the rights of pregnant workers across the U.S. By understanding the law and taking the necessary steps to put the proper protections in place as an organization and creating a collaborative process with our employees, we can not only maintain compliance, but create an awesome place to work for all of our people. Thank you so much for joining me today. If you enjoyed this video, please make sure you hit like and subscribe and check the rest of our awesome videos helping you to maintain compliance and build the type of culture that attracts top talent and keeps them for a long time. Thanks for joining me today. Have a wonderful day.